business boosting content, subscribe to our channel, hit the notification bell, and like our posts.
All right, a very good morning to all our SMEs across the nation. A very big welcome. Great to be here. Webinar Wednesday. Always highly enjoy this session. Huge engagement. And of course, as we all know, Webinar Wednesday started in the early days of the pandemic and has become one of the leading platforms or business webinar series globally. So, and I'm always excited to host. I've met some incredible people like I'm going to be doing this morning, but please let us know where you are. Let me put my chat box on. Let me know where you are, where you're coming from, or what your intentions are here this morning. And of course, as we move along, please pop some questions into the chat box so we can address them. And I always say, if we don't address your questions online, please pop an email to our team afterwards, and we will get those answers for you immediately. But yeah, tell us where you're from, and of course, I know that Carl's from Bloemfontein. We're going to talk to Carl in a few seconds, and I'm in Cape Town at the moment. So again, let us know where you're from, and then of course, don't forget to pop those questions into the chat box. Now, importantly, technology. We do know that sometimes technology disappears or fails on us. Please don't leave us. If something goes wrong, it doesn't usually. Let us know, and always important to say, we'll be back. But importantly, and again, for all those of you and for the first time this morning, we trust that you will enjoy. And for those of you coming back, thanks for being back. Always good to see you guys. And I always recognize in the chat box those committed, amazing business owners who are with us just about every webinar Wednesday. But this morning's important. You know, I was talking earlier on with Cole offline, who I introduced in a few moments. You know, HR, labor, CCMA, often nice words that we hear in our businesses. But, you know, we've got to take a closer look at that and to see how we can mitigate these challenges. But, you know, a lot of HR problems evolve around emotion. And I know that Cole's going to allude to that in a few minutes. And so let me not waste any time. Cole, please join me on stage. This is now Cole Ranger. He's the head of training at Consolidated Employees Organization. I'll just say CEO if you don't mind, Cole. But certainly great to talk to you. I love Bloemfontein. I haven't been there for a long time, but I know that's where you are based. And Cole, firstly, a very big welcome, and thank you for talking to us on this incredibly, look, HR, labor, CCMA, labor courts, we hear this often, but, you know, we know it's big in the enterprise world, but certainly massive within the SME sector. And Cole, but a big welcome to you. Thank you for joining us. Maybe you can give us a bit of insight into yourself and, of course, into the organization CEO, if you will.
Thanks so much, Mike. First of all, good morning to everyone tuning in. Mike, it's an absolute honor to be here. I've watched your webinar quite a few times now, and it's actually a bit crazy that I'm actually now on it, talking to you. So thank you so much for having me, first of all. Mike, so basically, Consolidated Employers Organization, we are a true and legitimate employers organization. Why I say that is there are a lot of fly-by-nights that act in the labor and employment sphere. And what we do is we specialize in dispute resolution, collective bargaining, as well as in training for employers and business owners across South Africa. We're nationwide, so wherever there's CCMA, an arbitration, if there's I always say this in our training sessions, if there's a tarred road or whether it's a potholed road and it goes to a CCMA, we'll be there to represent our members.
No, absolutely, Carl. And today's topic, Carl, and thank you again, and we appreciate your time, Carl, and of course the organization, Consolidated Employees Organization. Thank you. You're a great partner of the NSPC. You're making a big difference to our SME members throughout the nation, and we're truly grateful for what you do. But this morning is about the misconduct minefield, how employers get dismissals wrong and how to get them right. Sure, what a big statement. And this webinar offers practical insights, perspective, and clarity, empowering leaders to make defensible, fair, and confident decisions when misconduct arises. And, you know, Carl, I've got to ask you, but I've got a couple of, I'll be giving these questions because they're important questions, and I've been asked not to derail because it's designed for a specific reason. But, whenever I talk to a lot of SMEs all day, every day for over 19 odd years now. And my comment to them is always, when it comes to working with your team within, when it comes to the experiences getting nasty, keep the emotions away. But I know you're going to come to that in a few moments, so I'm not going to jump the gun. But let me start, Paul. And misconduct is one of the most common reasons for dismissal. We know that. What is misconduct, and why do so many employers still lose these cases? Carl, please.
Thanks, Mike. Such an important question, and I'll divide it into two segments for you just to get to the point here. So misconduct is one of the most common offenses in the workplace. It covers pretty much anything from policy breaches to employees coming late, anything that goes against the code of good practice, anything that goes against the disciplinary code of a workplace, and it basically acts against the interests of an employer or business. Misconduct itself is the most common referral, together with unfair dismissals, at the CCMA. As I said to you, we service the country nationwide. And basically, when we come to the CCMA, just from a practical point of view, you see this so often at the CCMA. It makes up more than 60% of all referrals. And we're talking about in the tens of thousands across the country in a year. So most employers don't just lose because of what an employee does. They lose because they fail to prove fairness. And it's something we hamper on in our trainings as well, that we try to get across to employer parties, we try to get across to academics and attorneys, is there are two main pillars in labor and employment law when it comes to dismissals, and that it needs to be substantively fair, which means there needs to be a good reason for the dismissal. So a fair reason would be, I caught this employee red-handed stealing apples. And then secondly, and this is the one that employers get wrong a lot of the time, is there needs to be a fair and just process that is followed. So we'll get into it a bit later. I'm sure with one of your questions, I can elaborate a bit more on the code of good practice, but there's two key failures that I see in practice. It's procedural shortcuts. Employers see that there's a good reason for dismissal, but then they won't follow a fair or proper hearing. Maybe the charges are very vague. They don't keep proper records. And a lot of the time, employers are unrepresented when they handle these things. They think because it's a workplace offense, it's my business, I can handle it. So they don't get the proper advice that they need from employers' organizations or internal labor consultancies. And then secondly, a weak justification of the sanction. So sometimes these things are predetermined. I just don't like the way you look at me in the mornings when you greet me. And because of that, I'm going over exaggeration here. You find a reason to no longer want to employ that employee. So what employers should focus on is the dismissal substantively and procedurally fair? And that is ultimately what we do from the back end. We look at it from the CCMA and the bargaining council, and we say, listen, is this dismissal substantively and procedurally fair? And if you can't prove both, you will lose that case. And that is the difficulty with misconduct. Thanks so much.
Carl, absolutely. And of course, without saying expensive. Carl, is it fair to say that most unfair dismissal findings stem from decision-making failures rather than legal ignorance?
Ooh, that's a good question. I'd say they come from poor decision-making. A lot of the time, what we see on the ground at the CCMA and the bargaining councils is that employers do understand the rules. I mean, they dictate the rules in their workplace, they set the policies, they set the procedures. But what happens, and I'll allude to what you said earlier, the emotional elements of it in the heat of the moment, they act emotionally, they maybe rush the process to get to a specific outcome, or they treat dismissals more of it as a punishment rather than a measured and operational decision. So from our side, what we see is a reaction to misconduct and not a response from employers. And that comes down to poor judgment more often than a lack of knowledge. And ultimately, that is what makes employers lose cases.
Yeah. Now, Carl, dishonesty is often described as going to the heart of the employment relationship. Does that mean dismissal is always justified?
Also a very important question. Thanks, Mike. So when it comes to the heart of the employment relationship, it's not automatic, but very often dismissals do, or dishonesty does relate into a dismissal. The reason being is that the trust relationship is a key element to the employment relationship in general. So without getting into too much legal jargon, the courts over many, many years, I'm talking into the 1900s, have identified that the key part that keeps a employment relationship between an employer and employee going is the trust relationship between them. From an employee's point of view, you work for remuneration, you are there to serve the interests of the employer based on a contract of employment, whether it's verbal or in writing. And from the employer's side is, I'm entrusting you to do the job that you're hired to do for a benefit, which I will pay you for, remunerate you for fairly. And there's that level of trust that goes with that. So when dishonesty is committed in the workplace, and I'll use an extreme example, gross dishonesty such as theft, that breaks that trust relationship down. I cannot trust you without me looking over my shoulder, watching you the whole time. And because of that, it makes the employment relationship difficult, if not impossible to sustain. So employers still need to prove that the misconduct occurred when it comes to the trust relationship. They need to prove the impact of the trust relationship of what this dishonesty has now done, and also that ultimately dismissal is still the appropriate sanction. A lot of the time, employers don't actually elaborate much on that. They assume it's maybe obvious, this person stole from me, so of course I don't trust them anymore. But how the courts and the CCMA and the bargaining councils look at it is that it's still important to say those things. It's still important to prove those things. So to get back to your question, it is a strong way to dismissal, but it's not automatic.
Yeah, and as one says, it's the process that counts as opposed to anything else. And I think that's where a lot of business owners of SMEs, I hear a lot of it, get it wrong. As you said earlier, the motion side, but then they shortcut it and they don't follow procedures, and there might be a huge offense there, but it's no good. The offense is there, but you're not sticking to procedures, and of course, which is critical when it comes to CCMA, as we know, Carl. Yeah. Now, Carl, negligence seems far more subjective. How do employers realistically distinguish between negligence and gross negligence? That's a good one.
A very good one. I actually wrote an internal memo for our organization a while back on the specific difference, because we see it being handled very differently at the CCMA than what the courts will handle. So basically, when it comes down to the distinction, it is an eye of the beholder offense, and it depends on the type of workplace or the type of industry you're in as well. It's human to make mistakes. Accidents happen, people, err. And basically, when it comes to negligence, if I can give it a short definition, it's the failure to exercise reasonable care. The distinction between that and gross negligence comes down to a serious or extreme departure from that standard, Mike. So when I break it down further and to simplify it for the audience, it comes down to certain key factors. And the ones that stand out to me are the degree of carelessness, the risk or damage caused, and then the employee who committed the negligence, their role in the workplace, what skills and training they've had, and the responsibility placed on top of them. Where it gets interesting, and maybe between negligence and gross negligence, a more seasoned employee with more experience in a higher position, let's say a manager who's in charge of a team, there is a higher duty of reasonable care placed on their shoulders versus maybe a general worker. So immediately, the process that will follow and the charge that will follow will differ between negligence and gross negligence. Where the CCMA and bargaining council make it interesting and make it interesting for our jobs, representing employers, is that when they look at negligence, they automatically assume, and not across the board, but from what I've seen, that there needs to be a damage element to the negligence. So if I've made a mistake in the workplace and it hasn't cost the employer actual money, then it's not negligence. What's the damage caused? And what they don't realize is it goes back to the trust relationship. If I can't trust you to do the job to the standard that I require, it breaks that trust down. It might not justify dismissal on first offense, but you can follow a progressive discipline approach to try and rectify that behavior. And ultimately it might lead to a situation where there's just too much risk in keeping you employed here. You cannot do the job to the standard that we require. And because of that, we need to look at a disciplinary hearing for progressive discipline for negligence. So The higher the skill level, the higher the risk, and the lower the tolerance.
Yeah, no, 100%. Now, Paul, insubordination is frequently confused with insolence. Why does that distinction matter so much in dismissal cases?
Oh, so this one's an interesting one for me. It actually tripped me up a bit when I started in labor and employment law many years ago. But there is a fundamental difference between the two. And I see employers who are unrepresented often get this incorrect. So to give the distinction, insubordination can be seen as a refusal to obey a lawful or reasonable instruction from the employer. So I'm asking you to follow this policy because this is the reason and this is what the outcome will be. Insolence can be more seen as disrespectful behavior. So being sassy at work, talking back, any form of disrespect or making someone feel insignificant, or even, not bullying per se, that is harassment, but it goes down to that behavior and that relationship. So insubordination at the end of the day can justify dismissal if it is gross and deliberate. And what the courts have often said is that it needs to be repetitive on that front. So if I just don't follow an instruction right now and I tell you to go fly a kite, that is first offense. You can issue a warning. If I repeatedly tell you to fly a kite on that, offense, or in that moment, even if it is part of the same cause of action, it can be seen as gross and deliberate and can justify dismissal. Where insolence comes in, it's usually less serious and requires progressive discipline. So there, it's much harder to prove dismissal on first offense unless it is extremely disrespectful behavior. But again, that also depends on the relationship between the two individuals, usually the employer and employee-employer. And mislabeling these offenses can often lead to disproportionate sanctions. And that is where the distinction neatly comes in for employers to get it right. Thanks, Mike.
Yeah, Cole, that comes to my next point. When it comes to the trust relationship, why is it so central to misconduct dismissals, and why do employers struggle to prove its breakdown?
So going back to the trust relationship, as I said earlier, it is pretty much the heart of the employment relationship. And what people fail to realize, and I think, going into a lot of businesses who are unrepresented in this front, they don't see the importance of that trust relationship. It's not enough to just prove misconduct and say, yes, this person stole this and they did this, because they automatically assume that it's obvious that the trust would break down. Sometimes it's not even addressed. So the question that actually pops up, and that it's easy for employers, and this is the tip that I can give all the employers and SMEs out there, the question is, can this employment relationship continue in the face of this offense or misconduct that you've committed? So the trust relationship is the foundation of the employment relationship, and employers often struggle with that because they do assume it's obvious that this trust is broken down, that we cannot continue this relationship. They fail to lead evidence on it, whether at the disciplinary hearing or at the CCMA at arbitration. And then they don't often explain the impact of misconduct on the business itself. So to wrap that into a neat package for our viewers out there today, is when you are proving not just the misconduct and the reason of why this is a serious offense. And again, I'll use theft as an example. People assume that if you're caught stealing, it's a criminal offense, it's an offense within the workplace, and I caught you red-handed, so why should I have to follow the process? But that's the thing. The labor and the employment law protects both parties, the employer and the employee, but there's an emphasis on the protection of employees because they are seen as the vulnerable party in that relationship. And because of that, the employer does need to follow certain procedures, certain processes in coming to the right and fair conclusion that, yes, this person was caught stealing, but we've given them a fair opportunity to have a say. We've given them an opportunity to have their version heard by a third party, a neutral third party, such as the chairperson, or when we get to the CCMA, the commissioner. Based on that, we can say, yes, we followed the procedure, the correct procedure, that's fair, and we have a good reason to dismiss, which is that substantive fairness element that I mentioned earlier. With all of that, it goes also to the trust. And this comes in with a lot of employers who don't understand the Labor Relations Act. So what the Labor Relations Act prescribes is that the trust relationship needs to be proven to be broken down to stop reemployment or retrospective reemployment. So for an example, if an employer loses a case in arbitration because the commissioner might find that the sanction for dismissal was a bit harsh, maybe they see this guy's got a clean record, he's worked 10 years, he's got a family to support, and it was a first offense, and the employer, listen, I assume that it's obvious that this person can't be employed here. The Labor Relations Act prescribes retrospective reinstatement as a primary remedy. So where there's no breakdown of trust, or the question that I posed earlier, can the relationship continue? If the commissioner feels the relationship can continue, they can replace that employee back in employment retrospectively. So for all the months that they have been unemployed pending the outcome of the CCMA. The employer then needs to compensate them for those months of loss of income. And that's where the danger comes in not proving the breakdown in trust. It's a very simple thing to do. You just say, listen, this is why it broke the trust relationship. This is why the relationship cannot continue. Here's the evidence to show that this person has done this, and because of that, I cannot continue this employment relationship. This is the impact of it on the business. So basically, in a nutshell, that's the importance of it and why employers struggle to prove it. Thanks, Mike.
Yeah, and Cole, and I mean, in a nutshell there as well, is that, if one that happens, reinstatement, and especially in a small business when you've got like 6 or 7 employees and a business owner, and now that person is forced to come back, there's a lot of animosity, there's a lot of, the environment is unpleasant, and that doesn't go away. We know that. And of course, then what happens is then the business owner tries again, which catapults some problematic situations. So, and we've seen that at the NSPC. Many of our SMEs are kind of embroiled into that. And a question coming through now, someone's asking, I'm a manager of a small business. I've got 6 people, and I'm going through a misconduct process. And unfortunately, at my stage, I don't have sufficient funds for a professional organization, but next time I'll do that. And I've got a manager who's a complainant, and I am the chairperson. And how does the CCMA view that, knowing that we're a very small business with limited funds, and we may not have the procedure perfect, but the principles are intact? What is your opinion with that, Cole?
So I think that's actually a lot more of a common situation than what we make it out to be on paper. So objectively and ideally, you want a chairperson and disciplinary hearing to be a third neutral party. Often there are internal labor consultancies that companies, enlist their services of to give compliance advice, to tell them that, listen, yes, this is the correct way to go. This is not the correct way to go. People have this misconception that if I pay a labor consultancy, they'll do what I want. No, you're paying them to tell you that this is correct and this is incorrect, and to guide you to come to the correct decision. So in a situation like this, for the viewer who's asked the question, there's nothing wrong with using the resources that you have at hand. Owner or the chairperson. Yes, there might be a bit of perceived bias, but it's not inherent. You just need to act objectively. You need to remove the emotion out of it. It is your business. And if you can prove, say it goes to the CCMA and there's an allegation that this hearing was completely unfair because you were the chairperson, there's nothing wrong with your manager being the complainant. We call them the initiator in disciplinary hearings. So the manager being the initiator, that's perfect, because they were the person that they were reporting to. They were able to see the offense being committed. Maybe they're an eyewitness, so they can lead the evidence for that. But you as a chairperson still need to come to the correct decision based on substantive fairness. So there has to be a good reason for the dismissal based on the evidence and the testimony that you hear at the disciplinary hearing. And then also you have to ensure that the procedural elements are followed. So if it's your first time chairing a hearing, you need to be very careful that you are getting, even from the internet, if you're Googling, what are the procedural elements I need to follow as a quick and easy. We have many articles on that. These conversations aren't unique. They're all over the internet. And you just need to make sure that you're following the correct process when chairing those hearings. But when it comes to the CCMA, it's not inherently wrong and it's not inherently biased. And the reasons you've given us, you're a small business, maybe you don't have the resources or the funds to find a third neutral party. And because of that, that is a justification that won't just lead to an unfair hearing. But you need to follow the other elements as well. And there are 12 of them to tick off as a checklist for you for procedural fairness. So I hope that answers your question.
Yeah, Cole, that's important. Thank you for that. And what you're saying there is that if you have to chair the meeting and you'll manage the complainant, that's okay. Not the perfect scenario, but okay. But as long as you follow procedures and keep the emotion away from the engagement, then of course you can move forward positively in that direction. Now, Cole, from your experience, what procedural shortcuts most commonly cost employers their cases? Now, I find this interesting question.
Yeah, no, this is a very interesting question. It feels like I'm ranting on employers a bit here, but it's to guide them and to get them, to understand the seriousness of the lack of procedure. And it ties into the question we've just been asked now from the audience as well. So when it comes to procedural shortcuts, something that we often see in practice is new business owners, maybe some business owners who have been doing certain things for a very long time in a certain way, and for lack of a better word, getting away with it because they've never been taken to the CCMA. Now, all of a sudden, the way I've been handling my business and disciplinary action and hearings is being challenged at the CCMA as unfair. What that comes down to, again, is procedural shortcuts. So no proper investigation, vague or poorly drafted disciplinary charges, no real opportunity for the employee to respond to the charges. That's just sort of, this is what I saw you doing, get out of here. Completely wrong. In your case, will fall flat because you cannot prove procedural fairness. There can be predetermined outcomes. So I know I want to get rid of you, Mike. I don't like the way you look at me in the mornings. I don't like the way you slurp your coffee in front of me. And I'm going to, as a part of being human, subjectively and maybe subconsciously find a reason to get rid of you. So I'm going to be extra hard on you when you don't meet your deadline, versus someone else who, it's fine, I'll give you an extra week. So there's predetermined outcomes that shape I've decided on what I want to do, and I'm finding a means to fit it. Something very common is not keeping proper records, employee files. If you serve a notice on someone, if you serve a warning on someone, all of that should be documented. So when it comes to the overarching shortcut, is that a lot of employers, if I can sum it up, will have a great justification to dismiss someone, a great reason: theft, gross negligence. This person wrote off the vehicle without, he was driving it without my authority, caused damages, insurance won't pay. But then they won't follow the proper procedure. They won't give that opportunity to the employee to have their say. And the law prescribes that, regardless of whether you think that this is a closed and shut case, that procedure still needs to be followed. That is how South African labor law has been formed. And those two elements of substantive fairness and procedural fairness need to be there. So procedure doesn't need to be complex. And it goes back to the previous question we received from the audience. It doesn't have to be complex. The code of good practice, so the code of good practice is on dismissals. It is called Schedule 8 of the Labor Relations Act. You can find it there. It was recently amended at the end of, towards the end of last year, in September last year. And basically it's a guideline for judges, commissioners, employers, and employees on how to go about dismissals in a fair and reasonable manner. It prescribes those two elements of fairness. And what it dictates is that there needs to be a genuine dialogue between an employer and employee, whether in the form of a formal disciplinary hearing, but it also understands that smaller businesses who don't have the access to funds, who don't have the access to resources, can have a more informal process. So long as it is still documented, so long as you can still procedurally tick those boxes, whether it is formalized or informal. The difference comes in with more prominent employers who are larger in scale. There is more of a strict approach required for them because there's more expected of them, based on their access to resources and so forth. So when it comes down to it, procedure doesn't have to be complex. It needs to be fair, consistent, and if I can give a tip, always documented.
Carl, I've got a very worrying message just landed.
Ooh.
And I've been called to the CCMA. I've been through a process. I've given a final written warning. I've now dismissed. I think I've done my stuff right. Not totally sure. What could I expect of the CCMA? What is a fair conclusion, and what could I expect as a typical bad scenario?
Well, if you follow our advice this morning on this webinar, then you've got nothing to worry about.
It's too late.
But is it too late? Well, luckily we specialize in damage control. So when the matter comes to us and our officials who handle these matters at the CCMA, what has already happened at the disciplinary hearing has been concluded. So basically, we are looking backwards and seeing that what happened on the day of this hearing, on the day of the offense, and the process that was followed to get to a dismissal, whether there was warnings issued. We basically have to check whether what happened that day was procedurally and substantively fair. I might sound like a broken record, but those are the two key words here. And in your scenario, to the viewer in the audience who's now posed the question, you've issued warnings, so you can tick the box there. You followed progressive discipline. And there's a distinction there that the courts and the commissioners love, because the Code of Good Practice actually prescribes dismissal as a last resort. All right. So employers should follow progressive discipline to correct the behavior and not necessarily to punish it. So issuing a warning and giving you a second chance, a second bite at the cherry, to do things right, to follow the correct standard, to meet the outcome or whatever it is. And that warning then will lapse after 6 months, 12 months, 3 months, whatever the validity is. The issue comes in here with the question is that you've issued warnings. You've now, I'm assuming and hoping, crossing fingers, that you've had a disciplinary hearing, that you've given this employee a fair chance to have their say as to why they should not be dismissed. You've got evidence to show that this is why the trust relationship has broken down, and now it's ended up at the CCMA. What you can expect there, if you haven't appeared yet, is the matter will most likely be set down for conciliation first, or con-arb, which basically means that the conciliation, which is more of a mediation, it's an informal process. The commissioner will guide the parties to see whether there's an amicable outcome that we can come to. So a settlement agreement, maybe we ventilate some of the facts, and it seems that the applicant or the employee doesn't have a good case, and they can then withdraw the matter. Once that process has been concluded, you will then proceed to arbitration, either on a different date, if it's only set down for conciliation, or if it's a con-arb process, which means the conciliation and arbitration are held together, you need to object to that process 7 days before the time to split them. If you don't object and you proceed to the conciliation, you will need to lead evidence and witnesses, as you did in the disciplinary hearing, to prove procedural and substantive fairness. And basically, both parties will have an opportunity to present their case. If you are unrepresented and employee is unrepresented, there will be a more informal approach taken by the commissioners that will guide the parties. It's a lot less formal in court proceedings. You sit around at a boardroom table, basically. There's an interpreter present, and the commissioner will gently guide the parties to get to the outcome of the arbitration or to reach a possible settlement. So I'm assuming that is where you're at the moment. For the viewer, if there's a follow-up, I'll be happy to answer it.
Yeah, thank you, Carl. I've got a few coming through, but we'll get on to the next question. Carl, how should employers balance discipline as a corrective tool versus dismissal as a last resort?
Basically what we were just saying now. So discipline ultimately is meant to correct the behavior and not necessarily to punish it. I think that is where employers get things wrong as well. Again, not to rant on the employers, but to give the guidance of saying this is how you do it correctly, and this is why it looks wrong on the back end when you get to the CCMA. So the Code of Good Practice, as I was alluding to, Schedule 8 of the LRA, it prescribes progressive discipline as the first resort and dismissal as the last resort. When that code is promoting progressive discipline, it means that you need to start with warnings, verbal warning, written warning, final written warning, and that will escalate as the behavior continues. So if the misconduct is still being committed, and I'll use a very simple, practical example. I luckily reside in Bloemfontein, so there's not much traffic, so there's not much excuse for me to be late to work. But in Gauteng, in Cape Town, the traffic's very congested. So maybe on first offense, the employer lets it slide. But operationally, it's affecting my workplace if you are late consistently. So I'm going to have to issue you with a verbal warning. Now, a verbal warning is still written down on a piece of paper, but conflicting there, but it needs to be documented as a warning that's been issued. You can escalate it on second offense. Maybe the next week they come late again. There's a written warning. And now they're 2 hours late because, traffic is an issue. But the thing is, we know that it's an issue. So you should plan around that, leave earlier in the morning if possible, or come to some sort of resolution with your employer that there is an exception or at least an understanding between you. Where there is none, those warnings will escalate to correct the behavior. Consistent late coming will escalate those progressive discipline measures, and ultimately the employer is giving that employee a chance to correct the behavior. If they fail to correct it, it will lead to a disciplinary hearing. Now, where the disciplinary hearing comes in is that the outcome of that can lead to a dismissal as a last resort, but it is reserved for more serious misconduct. So although individual offenses of late coming are not seen as serious by themselves, collectively, they're impacting my business. I can't trust you to do the work that you need to do, going back to the trust relationship, because you're not at work to do it. And that is now impacting us financially, operationally. Maybe you're in a position of authority and you need to lead a team, and now the team can't find you, you're not there. So the key question that employers can ask is, can this employee's behavior be corrected, or is the relationship no longer sustainable because of this? And that will dictate the difference between following disciplinary action, as in, shorter measures or measures short of dismissal, or proceeding to a hearing, giving them the opportunity to have their say and possibly coming to the outcome of dismissal, or even a final written warning. It doesn't always have to lead to the ultimate dismissal. Sometimes employees opt for a hearing instead, And based on their choice of going through a hearing, they might end up with a final written warning based on the evidence or whatever it is. Employers also reserve the right. So an objective third-party chairperson will tell the employer or suggest to the employer, basically, based on the evidence, based on the witness testimony, this is the recommended sanction. Let's say it's dismissal based on the seriousness of the offense. The employer is the custodian of the workplace. It's their workplace. They are the ones who have the relationship with the employee, and they can still tell the chairperson, listen, although you've recommended dismissal based on the offense, I still want to give this person one more chance. So can we lessen that sanction to a final written warning? And hopefully they can correct that behavior. So the employers also reserve the power in that relationship. It's their workplace. They should dictate how it goes. It's not the chairperson who's saying you have to implement dismissal because this is the evidence before us. And so that's the question that you need to answer. Can it be corrected, or is that relationship no longer sustainable? Thanks.
Yeah, Carl, we can talk all day. It's important. But Carl, yeah, another question is coming through. I know we'll address some of these after air. Just that, I've unfair dismissal charges. I believe it's fair. I'm going to the CCMA. Financially, what is the worst I could expect?
Ooh, okay. I'm going to burst your bubble here, unfortunately, Mike, and for the viewer. So unfair dismissals are seen as very serious if it is unfair. If you believe it is fair, you're off to a good start because you at least, hopefully based on the advice and the information we were sharing this morning, can retrospectively look back if you followed those two elements, substantive and procedural fairness. There's a good reason, you followed procedure, you've given the person an opportunity to respond. Worst case scenario, and this is not the nice part we like to advise, but the CCMA has the jurisdiction, the commission has the jurisdiction to issue up to a 12-month award when it comes to dismissal matters. So 12 months compensation, that is worked out on their basic salary, not the gross salary. So let's say the person has a gross salary of 15,000 and a basic salary of 10. So if you lose the arbitration, maybe you didn't have a disciplinary hearing, maybe you didn't have a good reason to dismiss, we are looking at worst case scenario retrospective reinstatement for the months that they have not worked. So let's say you dismissed them 12 months ago, then it can reach up to 12 months. If this hearing only happened 3 months ago and they are re-employed with full back pay, then we're looking at 3 months compensation. So 10,000 times 3 is 30,000, and they will obviously be back in your employment, which will make it difficult emotionally on that relationship. You can't remove the human element out of it. But worst case scenario, we're looking at a 12-month award, maybe no reinstatement, but that is extreme. And the commissioners at the CCMA and the bargaining councils do not often issue 12 months award. There's in extreme cases where there's been no procedure followed, there's no good reason. And commissioners do have to justify that outcome as well in their award, which you then can challenge on review at Labour Court, should that be the case. But yeah, that is worst case scenario. It doesn't happen often, but it's hard for me to predetermine what the outcome can be at this stage.
Yeah, sure, Cole, it's good to know that, in the back of your mind. And I think for every business owner, that could happen if I don't do this. So I think it's a psychological advantage for people to know that and to prevent that. Because I think, like you're saying and listening to you, Cole, you could prevent almost anything if you just do the right thing. And it's a matter of choice, isn't it? Just make the right choice and surround yourself with the right people like yourselves. And things won't go that way. So thank you for that. And just before on the next question, I know we've got 3 questions, Cole, remaining, but can I have legal representation at conciliation and arbitration and the Labour Court?
So Labour Court, yes. I would highly suggest when you get to the Labour Court, because that is a more formal setting, you before the judges there. The Labour Court is seen as the equivalent of the High Court. So there's a lot of procedures, a lot of process that need to be known. And if you're unrepresented, you're only disadvantaging yourself. It is a more expensive process, but you only get to Labour Court once you have gone through the CCMA and the Bargaining Council arbitration. And that outcome needs to be referred to the Labour Court on review. So my suggestion, Labour Court, you need representation, whether it is from an internal Labour company giving you advice, or an employers organisation advising you, and then appearing there with the correct legal representation, usually advocates and as legal representation in that level. When it comes to the CCMA and the bargaining councils and arbitration, legal representation is permitted, but it is restricted in terms of Rule 25 of the CCMA rules. The reason being is that legal representation is not automatic. So what happens is, if you are an employer and you are a member of an employers organization such as ours, we have automatic rights of representation for our members in those forums. So we do not have to apply. However, if an applicant or the employee party referring the matter rocks up with their attorney who's charging them, an arm and a leg to appear there, we often get them kicked out based on the technicalities of Rule 25. The reason being is that although I have an LLB, I was in private practice, I'm not appearing as an attorney in that forum. I'm appearing as a dispute resolution official for a legitimate and true employers organization. Yes, I have the legal knowledge and the backing, but that is for the employee's argument to make as to maybe a fair ground for representation. Their legal representation has to apply in terms of Rule 25. It needs to be done 14 days before the date of arbitration to give the respondent party, so the employer party or us as representatives, a chance to oppose that representation. There's various factors that need to be addressed, such as the legal complexity of the matter, the interest of justice, whether there is complexities in law that need to be addressed. And often what the commissioners do is they are the ones who will guide the employee who's unrepresented. So it's not automatic. In fact, it's more on the case of legal representation is not permitted. But the CCMA is a forum designed to assist vulnerable employees in situations where they do not have access to funds to afford representation. And that is why that whole objective of the CCMA was designed different from the civil courts. Although the outcome is also binding, such as a court order or a judgment, the representation element, the commissioner can reach in. They have the helping hand principle, so they can assist the parties, employers who are underrepresented and employees, to guide them through the process. It is more relaxed and informal. However, there is definitely still a need for that professionalism at the CCMA and those procedural elements to still be followed, such as giving both parties a chance to make opening statements, to cross-examine witnesses, to call recall witnesses if on legal technicalities. Where the legal representation element gets more prominent is in very complex matters where a lot of legal principles are being thrown around between the parties. There's jurisdictional or technical points. So there, I would suggest legal representation, but it's not an automatic thing. And a lot of attorneys, and I saw this, when I was practicing in Bloemfontein, a lot of law firms don't deal in labor law. So it's a very niche, unique area of law that, because most attorneys will represent the employee party, not the employer. Most employers have internal labor representatives or employers organizations who have automatic rights of representation. So there's a distinction there as well. So for any attorneys out there who are listening, please make sure you read Rule 25 of the CCMA rules, that you follow the correct procedure, and be prepared to be opposed on that front, because it does complicate a matter sometimes, especially if the attorneys don't have that specialization or expertise in labor law. So I hope that answers your question.
No, so Cole, what you're saying, quick one, is that a business owner can oppose for the employee to have legal representation.
100%, Mike.
And vice versa.
100%. Works both ways. So as I say, there's certain permissions for automatic representation. So for employers organizations, trade unions who employees are part of. So those are the two automatic. And then if you want to have legal representation, such as an attorney or an advocate, you have to actually follow the rules and apply. But it still remains the commissioner's discretion whether to allow it or not, and it can be opposed.
Okay, thank you very much. Cole, 100%. If you had to give one piece of advice to business leaders dealing with misconduct tomorrow, what would it be?
Ooh, slow down. Make sure that you follow the process, that you've looked at the facts, that you've removed the emotion. Most mistakes happen because employers try to rush things. They want to act too quickly. So take your time to investigate the charges, to call the correct witnesses, to have all that information on the table. Consider all the factors objectively. As I think is a theme for today, remove the emotion out of it, which is very difficult. And if you can't, maybe put someone in a position to make that decision objectively instead of you, because internally you have that bias. And follow a fair process. It's not difficult to have a look at these different factors you need to prove, but you need to slow down and take your time to do them. Once a dismissal has been made on that day, it's very, very difficult to backtrack that at the CCMA and to prove that what you did was fair. So just in short, slow down.
I like it. We'll remember that. All right, Cole, what does fairness really look like in practice beyond what the law requires on paper?
That's a very good question, Mike. So I think for a lot of people, fairness looks like perfection. You've got these procedural check boxes, as I've alluded to. So substantive fairness, procedural fairness, and there are these hard yes or no questions. Did you do this? Didn't you do this? But fairness isn't perfection, as the code of good practice does allude to and give guidance on. It comes down to reasonableness, in my opinion. So there must be a valid reason for the misconduct being committed and the sanction that follows it. There must be a fair process that is being followed, even if that is in the form of an informal hearing, a genuine dialogue where you can say, I've documented this, I've done this. And then lastly, a proportionate outcome. So the punishment must fit the crime, as that saying goes. So treating the employee in a way that you can justifiably objectify or objectively prove at the CCMA, at arbitration. And if you can explain and defend your decision, then you are likely on the right side of fairness.
Mm-hmm. Yeah, important words, Carl. Thank you. And do you think most unfair dismissal findings are really about employee misconduct or employer judgment?
Employer judgment. The reason being is that we don't struggle with going to the CCMA, and this is just from our perspective, representing employers where there was no misconduct committed. Where employers have shortcomings, and I think it goes back to our conversation earlier, is that they look at this in an unobjective way. They see that this offense has been committed, and they quickly jump to the conclusion that 100% this person can't work anymore. And then they try to fit the process and the rest of the procedural tick boxes to match the outcome that they've already predetermined in their mind. And it is human to do so. You have hurt me, you've hurt my business, you've hurt our trust relationship. I'm now reacting instead of responding. And because of that, I take shortcuts. I just want you out of here. I maybe don't follow proper suspension or whatever it might be. So it comes down to the judgment of the employer. And that's something that can be easily rectified if you just take a step back, breathe, slow the process down, and look at the bigger picture in front of you, Mike.
Now, Carl, you've excited a lot of people, and you've made quite a few people worried this morning, which is important. But let me ask you a question, Carl. How can SME South Africa get in touch with you? What can you do for SMEs throughout our nation? You know, we know it's the lifeblood of our society. It's the future of employment, and we need to protect our SMEs. And what can, in short, to abbreviate your company's name, CEO can do for SMEs? And after that, Carl, how can they get in touch with your organization, get involved, if you don't mind?
100%, Mike. Thank you. No, so CEO, the Consolidated Employers Organization, as I say, we are an employers organization. We specialize in representing our member employers. So specifically SMEs, large companies, small companies, ones that have just started, ones that have been around for decades. We represent them all. We are the largest employers organization in South Africa, and we give that expert representation. We are peer there at the CCMA for the employer to act in their best interest and on their mandate. So we specialize in that dispute resolution element. Where workplace dispute arises, we cannot assist with a disciplinary hearing because we are a true employers organization. But once that disciplinary hearing has been concluded and an outcome has been made, and it gets referred as a dispute to the CCMA or the bargaining council, that is where we step in on behalf of the employer. And obviously we can provide the compliance and guidance to the employer. We represent them to the best of our ability with our expert officials across the country. And we also specialize in collective bargaining and training. So our collective bargaining department is actually pretty huge. We represent employers across 5 different councils in South Africa, and we basically are the voice for employers in those councils. So when it comes down to decisions being made on wages in the main collective agreements, we represent the employers in those industries. We give them a voice at the table. And then lastly, when it comes to the training, we want to equip employers to handle these disputes as per our discussion here, give them the tips they need, tell them how to do these difficult things that seem maybe very daunting from the outside. But once you get the hang of it, and you are equipping yourself and upskilling yourself, you will better understand how to work in conjunction with internal labor companies, with us here at CEO, and then lastly, to make better decisions moving forward. And all of that can be a prevention and not a cure. So dealing with it at its source rather than having to deal with the aftermath at the CCMA and what we call damage control. In terms of getting into contact with us, so I mean, we have 2 websites. We have our main website, which is the Consolidated Employers Organization. If you type it into Google, it'll pop up. It's ceo.org.za. And basically what we come also have a website for is for our training department, which is CEO Academy, which you can also type in the Consolidated Employers Organization. We have a tab over there. But to be a member of us, we do have those forms available. You sign a membership form, you pay a monthly membership fee, and then you are an active and valid member for us, and we can afford all these services to you.
Fantastic, Carl. And just my last question. I know we spoke about this earlier, the change how life works these days. Can business owners consult with you online, in person, and what would be the process there?
Oh, 100%. So because we have a national footprint across South Africa, we obviously want to work for the convenience of the employer. So when it comes to consultations, whether it's telephonic, virtual, in person, we do have offices throughout the country. Our officials are, in remote regions as well. So we want to give that ease of access to employers. Certain employers prefer in-person consultations. Other ones prefer a quick phone call. Other ones only want to meet on the day of the CCMA. So we try to accommodate employers across the board for whatever their needs are. And it's one of our main objectives at CEO is we want to identify what an employer's needs are, what our members' needs are, and we want to meet those needs where they are specifically.
All right, Carl Ranger, Head of Training at Consolidated Employers Organization. It's been an absolute privilege, super insightful. I've really enjoyed it. And I know many of our SMEs around the country have, and I think that things are going to change. Dismissals will be changed forever. And so thank you for your insights, Carl. I have no doubt many more to come, and all the very best. And to all our delegates, thank you for attending. I know the feedback's coming super strong in my inbox here and my WhatsApp. So truly appreciate to all our attendees. Without you, we can't do with what we do. And until the next time, thank you all. Truly, thank you, Carl. Much appreciated.
Mike, thank you so much for having me. It was an absolute pleasure. See you again. Thank you.
For more business boosting content, subscribe to our channel, hit the notification bell, and like our posts.